an update on the scrutiny of European authorities on vertical practices. First of all, I would like to introduce myself. I'm Pierre Zelenko. I'm a partner at Linklaters Paris, specialized in competition law. One of the specificities of our competition team in Paris is that we have handled and still handle a number of vertical cases involving several of our clients before the French Competition Authority. It is often said that France has the most active competition authority in Europe with respect to vertical restraints, and particularly resale price maintenance. This is true. France is also known as being one of the stricter authorities in this respect. It is also true that for several years the European Commission has focused its efforts on the fight against hardcore cartels and abuses of dominant position, and to a lesser extent on vertical practices. However, there are other national authorities that are taking action against resale price maintenance and other forms of vertical restraints, and which take these issues very seriously. And the European Commission itself recently opened an investigation into potential restrictions on online sales in the distribution of electronic product sector. The purpose of today's presentation is to provide you with an overview of the recent trends of national competition authorities in relation to vertical practices. To facilitate the discussion, I would like to divide the time in three topics. We start with resale price maintenance, first topic, then we provide an update on online sales restrictions, second topic, and to finish with, we will see together client and territorial restrictions. Since I have a good knowledge of the French Competition Authority's approach to vertical restraints for each of these subjects, after having quickly recalled the basic rules under European law, I will talk about the approach and the recent cases of the French Competition Authority, and then I will look at the approach and the recent development in various other member states. So let's start with resale price maintenance. As a reminder, resale price maintenance, also called vertical price fixing, involves a supplier or a manufacturer of a product specifying the price or the minimum price at which a downstream distributor or retailer can sell the contractual product. Let's see the European practice to start with. For the record, at a European level, Article 101(1) of the treaty prohibits agreements which may affect trade between member states and which have as their object or effect the prevention, restriction or distortion of competition within the internal market. However, an agreement that is picked up by this article may nevertheless be exempted under Article 101(3). The Commission vertical regulation exempts from Article 101(1) of the treaty certain vertical agreements, those agreements between companies active at different levels of the logistic chain. Let's start with resale price maintenance, which is our first topic. Needless to say that under European law, resale price maintenance is prohibited, and that the vertical regulation and vertical guidelines of the European Commission consider resale price maintenance as a hardcore restriction that cannot benefit from the block exemption. More precisely, Article 4 of the vertical regulation excludes from the block exemption restriction of the buyer's ability to determine its sales price. On limits to this prohibition, the supplier can impose a maximum sale price or recommend a sale price, provided that they do not amount to a fixed or minimum resale price as a result of the pressure from or incentives offered by any of the parties. What's the standard proof required by European jurisdictions to demonstrate resale price maintenance? The European Commission has condemned resale price maintenance on various occasions. For example, in the Deutsche Philips case in 1973, and more recently, the Volkswagen case in 2008. All these cases are rather old now, but appear from the vertical guidelines that they are the precedent on which the undertakings rely upon to analyze their behavior and, if need be, adjust their practices. The standard of proof relied upon by the European Commission is usually constituted of evidence such as explicit wording prohibiting the setting of prices at a lower level than that fixed by the supplier, or the requirement to obtain the supplier's approval to do so. What's the standard of proof required by the European jurisdictions to demonstrate resale price maintenance? The European Commission has condemned resale price maintenance on various occasions, in the Dutch Philip case, for example, in 1973, and more recently, the Volkswagen case, which spans from 2001 to 2008. All these cases are rather old now, but apart from the vertical guidelines, they are the precedent on which the undertakings rely to analyze their behavior and, if need be, adjust their practices. The standard of proof relied upon by the Commission is usually constituted of evidence such as explicit wording prohibiting the setting of prices at a lower level than that fixed by the supplier, or the requirement to obtain the supplier's approval to do so. Warning, threats, and/or sanctions to non-compliant distributors that deviate from this practice, and discussions regarding pricing discipline between a supplier and its distributors. However, the European Court of Justice, in its judgment of 30 July 2006 in the Volkswagen case, confirmed the annulment by the General Court of the decision of the Commission. Both the European Court of Justice and the General Court require the Commission to examine whether an agreement could be found between a supplier and its dealers. The Court of Justice and the General Court considered that the decision should be annulled since the Commission had not established a sufficient concurrence of wills between the supplier and its distributors for there to be an agreement for the purpose of Article 101. In other words, explicit or tacit acquiescence by the dealers. Also to be noted under European law is the following fact. In theory, undertakings could try to get an individual exemption under Article 101.3 of the treaty. In recent years, there has been a growing recognition by some legal authors that in some cases there may be efficiency arguments in favor of resale price maintenance. In practice, the Commission evoked this possibility on one occasion in a 1999 case concerning a newspaper publisher imposing a cover price on newspapers. The General Court ruled in 1994 in Matra Hachette that the parties to any kind of agreement are entitled to defend it under Article 101.3 of the treaty. And the Commission has specified in its vertical guidelines the type of evidence that is required in support of a defense. Introduction of a new product, first. Short-term low price campaign in the framework of a franchise system or similar distribution system applying a uniform distribution formula, second. Let's have a look now at the French practice. As to the French Competition Authority, the case law is very abundant in relation to resale price maintenance, and the fines are high. The most well-known cases in which the FCA, upheld by the Paris Court of Appeal, has defined its policy and its approach to resale price maintenance are the calculators for students in 2003, the pet food case, the first pet food case in 2005, the consumer electronics in 2005, the Disney video cassette case in 2005 again, the luxury perfume case, this is probably the key case setting case law in 2006, cycle products distribution in 2006, the chocolate case in 2007, the PlayStation case 2007, toy distribution still in 2007, toy and fancy goods 2009, and the second pet food case, the most recent one, in 2012. So quite a lot of cases. Let's have a closer look at it. The standard of proof of the FCA is very strict for undertakings facing allegations of resale price maintenance in France. Except in the case where resale price maintenance is contractual, the Court of Appeal, in the perfume case, validated the method used by the FCA, relying on a body of evidence to demonstrate a resale price maintenance practice. This body of evidence is made of three cumulative conditions. First condition, distributor's knowledge of the resale price favored by the supplier. Second condition, the supplier monitors the resale prices of its distributors. This can take the form of threats, retaliation measures, when distributors deviate from the recommended price. And third condition, a significant application of the recommended prices by the distributors, in other words, more or less 80%. The most recent case decided by the FCA and upheld by the Paris Court of Appeal in October 2013 is the second pet food case, in which the FCA sanctioned pet food suppliers' practice consisting in imposing to their independent wholesalers, also acting as logistic service providers, the resale prices to be applied to breeders and retailers. These resale prices were negotiated directly between the supplier and the end customers, and then imposed to the wholesalers. The three suppliers were sanctioned by a 35.3 million euro fine in total. The abundant case law of the FCA shows undertakings that the approach of the FCA towards resale price maintenance, A, is very strict, and B, that the FCA, even in its fair cases, imposes very significant fines to sanction that type of vertical restraint. Let's now move on to other European competition authorities and jurisdictions. The French Competition Authority is not the only authority in Europe imposing sanctions and taking action against resale price maintenance. Other authorities across Europe, of course, have also developed an important case law on resale price maintenance and have shown strong interest in such cases recently. The first example is the United Kingdom. The OFT issued two statements of objection concerning alleged practices of resale price maintenance in 2013, which show a real interest of the British authority for vertical restraints. On 20 September 2013, the Office of Fair Trading issued a statement of objection to a manufacturer of sports bras and 3 UK department stores, alleging that they have infringed competition law by entering into resale price maintenance agreements that set a fixed or minimum resale price on a brand of sports bras. The OFT alleges that DB Apparel UK Limited entered into a total of 9 anti-competitive agreements with John Lewis plc, Debenhams Retail plc, and House of Fraser stores between 2008 and 2011. These agreements allegedly had the aim of increasing the retail prices of DBA's shock absorber, brand of sport bra, in each of the 3 department stores I've just mentioned. They applied on a national-wide basis to numerous products within the shock absorber range. And during that period in question, DBA was one of the leading UK brands with a share of approximately 50% of the market. Anne Pope, OFT Senior Director of Services, Infrastructure and Public Markets, said, I'm quoting, "The OFT takes allegations of price fixing seriously. Resale price maintenance limits competition between retailers and can lead to consumers paying higher prices." On 24 September 2013, the OFT issued a statement of objections alleging that Pride Mobility Products Limited, let's call it Pride, a manufacturer of mobility scooters based in Bicester, Oxfordshire, and some of its retailers have infringed competition law. The OFT has provisionally concluded that parties entered into agreements or engaged into concerted practices that prevented the UK-wide online retailers in question from advertising online prices below price recommended retail price for certain models of mobility scooter. These practices may have limited consumers' ability to get value for money. The OFT's provisional finding is that these practices occurred over various periods in relation to different retailers between 2010 and 2012. The second example of active competition authority with respect to resale price maintenance is the German competition authority, the Bundeskartellamt. We would like to quote two interesting decisions of the Bundeskartellamt in 2013 sanctioning resale price maintenance practices. On 31st July 2013, the Bundeskartellamt sanctioned Walla Heilmittel for having used different methods to enforce adherence to its price recommendations for cosmetic products. Walla's sales representatives regularly checked on the outlet sales prices and if the recommended prices were undercut. Walla threatened to refuse to supply its products or actually stop supplying the outlets. Walla introduced a selected distribution system which only included selected retailers. The conclusion and term of the contracts were made subject to the retailer's adherence to the recommended prices. The contracts also included clauses restricting internet sales, and Walla eventually was fined 6.5 million euros. On 20 August 2013, the Bundeskartellamt also sanctioned TTS Tool Technique. Its distributors were asked to strictly observe a non-binding price recommendation. The outlets were threatened with disadvantages such as worse conditions or contract suspension if they deviated from the price. TTS Tool Technique was fined 8.2 million euros. These are very high fines, as in France, for that type of restrictions, which shows again that national competition authorities also takes it seriously. Let's now move on to a fourth country, Austria. The National Competition Authority, the BVB, is also extremely active in the field of resale price maintenance. We have found 6 decisions sanctioning resale price maintenance practices between 2012 and 2014, which is very significant. Let's only quote 2 of them. The Rewe case of 13 May 2013. This concerned vertical agreements with some elements of horizontal arrangements as well on final selling prices and promotion periods between Rewe and its suppliers. Rewe was fined 20.8 million euros by the Austrian Competition Authority. In the Philips case, on 1st March 2013, were sanctioned illegal pricing agreements with distributors, and the Austrian Competition Authority asked the Austrian Cartel Court to fine Philips as high as 2.9 million euros. Except for the case involving some horizontal aspects, the fine remains more reasonable in Austria compared to the previous analyzed member states. In addition, we have also noted that the Austrian Competition Authority launched a consultation that ended on 1st August 2013 on a document clarifying its legal assessment of resale price maintenance. The document draws a list of practices that would be illegal, as well as a list of practices that would amount to illegal conduct. Let's now move on to Poland. This country also illustrates this trend in Europe for greater appetite for resale price maintenance. We noted that the Polish authority issued no less than 8 decisions between 2013 and 2014. Branded watches in 2014 is the first case. In this case, it was about fixing minimum retail prices by distributors with their trading partners by determining a maximum discount that could be applied by the latter. Contractors who failed to comply were threatened, and their cooperation conditions could be deteriorated. affecting their margin, or imposing obligations such as purchasing the products with cash. 2 distributors of branded products were fined for a total amount exceeding €265,000. Second example is the skiing gear in 2014 as well. Sport and Freizeit was obliging its distributors to sell the products it was supplying at predetermined prices and to fix the dates of off-season sales campaigns for 7 years. In addition, the company was imposing sanctions on those entities that were not willing to participate in the collusion. Distributors refusing to apply the pricing policy of Sport and Freizeit were deprived of the right to an off-season discount. Sport and Freizeit also reserved the right to terminate the cooperation with such distributors with an immediate effect whenever they were going out of the recommendations. Sport and Freizeit was fined up to €35,000. Third example is the Bonapolska case in September 2013. Bonapolska applied resale price maintenance with respect to products for construction and maintenance of wooden floors for 12 years. The practices involved fixed prices and minimum discount rates by retailers and wholesalers. In some cases, the company monitored the application of the rates and threatened sellers offering products at a lower price with the loss of their discounts, previously granted to them. Agreements concluded between the company and distributors prohibited the latter to trade in the areas served by other sellers, or to run the risk of losing discounts. Bonapolska was eventually fined €19,000. Bulgaria. A €1 million fine was imposed by the Bulgarian authority in July 2013, so this authority also takes resale price maintenance seriously. In Croatia, a confirmation by the Croatian High Administrative Court of a decision of the Croatian authority sanctioning MSG for having forced one of its retailers, Rivulus, to bring its resale prices in line with the price list. MSG suspended the supply of certain brands of HP laptops until Rivulus agreed to correct its resale prices. Denmark. In July 2013, the Danish authority fined Miele for resale price maintenance agreements with its dealers and for having prevented parallel imports. Miele and individuals of the company were fined up to €160,000. The authority also imposed a €215,000 fine on Villa and 2 individuals of the company in October 2013 for resale price maintenance in the clothes sector. This is the highest fine ever imposed for RPM in that country. However, new guidelines on fines took effect on 1st March 2013, which will potentially lead to higher fines for such practices in the future. Let's now move on to the second topic, the restriction on online sales. This is another hot topic in Europe nowadays. It relates to the development of the internet, obviously, and to restrictions on online sales. This is our second topic. Let's have a look at the European practice to start with. Under European law, since it amounts to a restriction of passive sales to end users, a restriction of online sales cannot be exempted under the restriction regulation, which prohibits, I'm quoting, the restriction of active or passive sales to end users by members of a selective distribution system operating at the retail level of trade, without prejudice to the possibility of prohibiting a member of the system from operating out of an authorized place of establishment. Such restriction is considered as a hardcore restraint in the vertical regulation. The European Court of Justice held in its Pierre Fabre judgment in 2011 that in the context of a selective distribution system, a contractual clause requiring sales of cosmetics and personal care products to be made in a physical space where a qualified pharmacist must be present, resulting in a ban on the use of the Internet for those sales, amounts to a restriction by object within the meaning of Article 101.1 of the European Treaty, where, following an individual and specific examination of the content and objective of that contractual clause and the legal and economic context of which it forms a part, it is apparent that, having regard to the properties of the product at issue, that clause is not objectively justified. As to the recent developments at the European level, we have also noted that on 5 December 2013, the European Commission confirmed inspections relating to potential restrictions on online sales. Commission officials initiated unannounced inspections in several member states at the premises of a number of companies active in the manufacture, distribution and retail of consumer electronics products and small domestic appliances. The Commission has concerns that the companies concerned may have violated EU antitrust rules that prohibit anti-competitive agreements or concerted practices. The Commission suspects that the companies subject to the inspections may have put in place restrictions on online sales of consumer electronic products and small domestic appliances. The FCA has also been active in relation to online sales bans. Recent French practice has been shaped by the European Court of Justice reply to a question referred for a preliminary ruling in the context of the Pierre Fabre case I've mentioned earlier. The question was referred to the ECJ by the Paris Court of Appeal after a decision sanctioning Pierre Fabre by the FCA. Pierre Fabre Dermocosmetic was ordered to pay a fine of 70,000 euros and decided to bring the case before the Paris Court of Appeal. The Paris Court of Appeal considered that the clause described earlier restricted competition by object following the above-mentioned reply provided by the European Court of Justice. Following this case, based on this judgment, the French Competition Authority adopted the same approach in the Bang & Olufsen case in December 2012. Bang & Olufsen was ordered to pay a 900,000 euros fine for having prohibited de facto the distributors from selling the brand's products online since 2001, thus weakening competition between distributors. Let's now have a look at other national competition authorities. Enforcing online competition seems to be a priority at the moment for a number of them. Let's now move on to Germany, where it has recently been stated by President Andreas Mundt of the Bundeskartellamt that the authority would maintain its focus on this area in 2014. The Bundeskartellamt also published a working document on vertical restraints in the Internet economy in October 2013, summarizing its views on this matter. We have noted 4 cases by the Bundeskartellamt between 2013 and 2014 concerning restrictions on online sales. First case, the Bosch rebate system investigation in January 2014. In this case, the German authority objected to Bosch dual pricing rebate system. The level of rebates declined as online sales generated by dealers increased. Bosch dropped its practice after the opening of the Bundeskartellamt investigation. The German authority dropped the case following this move by Bosch. Second case, the Gardena rebate system case in November 2013. The authority objected to Gardena dual pricing rebate system. Rebates differed depending on the distribution channels. In other words, brick and mortar as opposed to online retailers, with only the former being able to benefit from the full discount. Gardena committed to apply the same discount rate to both distribution channels, and eventually no financial penalty was imposed. Third German case, the Sennheiser case in November 2013. prohibition from sales of Sennheiser products via third-party online platforms, for example eBay or Amazon. In that case, the Bundeskartellamt considered that the prohibition on sales via a third-party platform, Amazon Marketplace, was not justified when such a platform was also an authorized retailer. No financial penalty was imposed in that case. Fourth case, the Walla High Metal case, already mentioned in relation to resale price maintenance at the beginning of our presentation. This case dates back to July 2013. The practice sanctioned by the Bundeskartellamt was clauses restricted internet sales in the contracts. Walla was ordered to pay 6.5 million euro as a fine. Let's now move on to the United Kingdom. On 5 August 2013, the UK Office of Fair Trading issued a decision finding that Roma Medical Aids Limited, let's call it Roma, manufacturer of mobility scooters and some of its retailers, breached UK competition law by limiting online sales. UK competition law is, on the substantive side, effectively the same as European competition law. So principles in this case apply EU-wide. The OFT found that Roma entered into arrangements with 7 UK retailers that prevented them from selling Roma-branded mobility scooters online and from advertising their prices online as well. This decision is important because it shows that the OFT in the UK, like other competition authorities across Europe, is keen to take tough action on restrictions on online sales. It is also important to note that the decision follows a study into the mobility aid sector in the UK carried out by the OFT in 2011, a kind of sector investigation. Let's now move on to our third and last topic, customer and territorial restrictions. Let's first have a look at the European practice. At a European level, territorial and client restrictions have been particularly harshly considered and sanctioned. In principle, territorial and customer restrictions cannot be exempted under the vertical regulation, which prohibits the restriction of the territory into which, or of the customers to whom, a buyer party to the agreement, without prejudice to a restriction of its place of establishment, may sell the contract goods or services. Such restrictions are said to be hardcore restraints. However, considering that territorial restrictions might be efficient, especially within selective distribution networks, a certain number of exceptions apply. It is notably so with regards to a. The restriction of active sales in the exclusive territory reserved to the supplier or allocated by the supplier to another buyer. B. The restriction of sales to end users by a wholesaler. C. The restriction of sales by the members of a selective distribution system to unauthorized distributors. And D. The sale of components to manufacture competing products to those produced by the supplier. The most problematic clauses are the restriction of passive sales and the prevention of parallel imports, which are considered as restricting competition by object. More recently, though, an exception has been found with regards to the restriction of parallel imports in the pharmaceutical sector that was found by the General Court and the ECG to be possibly exempted under Article 101.3 of the EU Treaty. Let's now move on to France. Recent French practice follows the principle laid down by the European Commission practice and guidance. As such, in its 2012 case concerning the pet food market, the FCA considered that when a supplier set up exclusive geographic areas for each of its wholesalers, and when it restricts passive sales, a restriction of competition could be found. Wholesalers operated over a limited geographical area determined by the manufacturer and also refused to sell products to retailers located outside their distribution area. One of the suppliers also prohibited its wholesalers from exporting products outside France by banning the delivery of products to veterinarians located outside France without the manufacturer's prior agreement. Such approach was upheld by the Paris Court of Appeal in October 2013. One of the most active European authorities in relation to territorial client restrictions in vertical agreements seems to be a country that, oddly enough, does not belong to the European Union, namely Switzerland, which also imposed the highest sanction by far among those cases we have found. In the BMW case, in May 2012, BMW was found by the Swiss authority to have restricted access to the Swiss market by preventing authorized distributors of the EEA to sell new Mini and BMW branded vehicles to clients in Switzerland. BMW was fined around 127.62 million euros. Let's now have a look at various other national competition authorities. Italy, to start with. The Italian authority launched an investigation in relation to the distribution contracts between Enavit and its dealers, which contained a ban on sales outside the territory or sales to exclusive client groups, and an agreement for an undefined duration based on non-competition. In Denmark, the Danish Competition Authority sanctioned Miele in July 2013 for having entered into resale price maintenance agreements with its dealers and prevented parallel imports. Miele and individuals of the company were fined for an amount exceeding 160,000 euros. Poland. In September 2013, the Polish Competition Authority sanctioned agreements concluded between Bona Polska and its distributors, prohibiting the latter to trade in the areas served by other sellers. They were facing the risk of losing discounts. Bona Polska was fined around 19,000 euros. To conclude, I would like to say that, to me, the conclusion is rather clear as to the fact that undertakings are under close scrutiny from competition authorities in relation to vertical restrictions. The utmost attention should be given by undertakings when building distribution systems and drafting distribution agreements. Sales force, both at suppliers and distributors level, must also be educated and alerted to these issues. Employees on both sides must be made aware of what they can or cannot do. These fines incurred are very significant, as we have seen, and the behavior of one employee only is sufficient to trigger the liability of the whole company. Let's not take that risk. To conclude, I would like to suggest a few recommendations for minimizing the risk related to resale price maintenance and vertical restraints in your undertakings. First of all, I think that it would be very important that your internal legal teams issue one-pager recommendations to the sales force to make them aware of these potential risks and suggest a few pieces of advice that they could apply very easily. Second, I would also suggest that the legal teams internally organize vocational trainings to make the sales force aware of those risks. This is the end of this presentation. I would like to thank you for your attention, and I hope that this will be profitable to you and your companies going forward. Goodbye.